Hello, my name is Michael Tessera and I prepared this presentation entitled Shining a Light on a Not So Classy Act. And I'll be looking at the case of Gill and Ethicon Sàrl, which is a federal court case. Justice Lee has issued this judgment, and I guess the reason I've called it Shining a Light on a Not So Classy Act, firstly, it was some litigation taken by Shine lawyers and it involved a class action in relation to pelvic mesh, which you may have heard of. And the problem with the particular case is that the Shine has recovered quite a lot of money from the amount that was to go to the group, and this was an attempt to get an extra $32 million out of the settlements to pay for what the judge described as commercial mistakes which it made in the way it funded this particular class action. So I think it's a negative case for class action firms. I think it does create a very strong impression of the firm being quite greedy, and so that's why I chose that particular image for this presentation. Bit of background about myself. I'm a competition and consumer lawyer, and I run my own legal practice, Sàrl Legal Consulting, which I've been doing for the last 15 years. And I help companies with competition and consumer law matters, also individuals. And prior to that, I worked at the ACCC 15 years in a variety of roles, including as Director of Enforcement. Now, the presentation I'll be structured with the background and the issues first, then look at the decision of Justice Lee, then look at the likely next steps in the litigation, and then finish with some commentary. Now, the background to the case is this was an application by Shine to seek a further payment out of an approved settlement, which was run by Shine lawyers. And it's important to recognise that Shine is a subsidiary of Shine Justice, which is an ASX listed company. And so this was a class action taken with three lead applicants, but there was a class of over 700 members, and these were women who'd suffered complications after surgery involving transvaginal implantation of synthetic mesh devices. And this very big litigation, very hardly fought, and some of the conditions that these women faced was urinary incontinence and pelvic organ prolapse, so very serious injuries suffered by the class of women. Now, Justice Katzman was the judge at the first instance, and she found that the relevant Ethicon devices, so Ethicon was the manufacturer, and they were actually distributed by Johnson & Johnson. The Ethicon devices had a defect within the meaning of that term in the Trade Practices Act. This just goes to show how long ago the conduct occurred. This is prior to the changes that repealed the Trade Practices Act and introduced Australian consumer law. So they're back in the early 2000s. And the conclusion was that none of these products were fit for the particular purpose for which they were acquired or were of merchantable quality. Also, the information that was provided by the manufacturer to women using the products did not warn of particular risks. And the class action resulted in an award of $300 million, which was described as being at the lower end of the reasonable settlement amount. So that's a relevant factor. Now, the issues in this particular case are summarised by Justice Lee quite nicely at paragraph 2. And as he says there, what is at stake is a proposed payment of well over $32 million going to solicitors out of the settlement sum, which would otherwise go to these injured women, in circumstances where this money was not recovered against Ethicon, even though the Shine case was entirely successful at trial and on appeal, and they received favourable cost orders. And he makes a further point in paragraph 3 that the deduction is proposed even though the solicitors have already recovered or claim to be entitled to recover $82 million for costs and disbursements. And as I said in the earlier slide, the settlement was described by Justice Lee as being borderline. And as you can see there, at the low end of the range of fair and reasonable settlement outcomes. The problem that Shine's got here is that if 300 million is at the lower end of the range, if you're going to take another 10% of that money out and give it to the lawyers, then it's likely to make the settlement unreasonable. Now, it's important to note the comments by Katzman in the judgment, which is like a 1,500-page judgment, which I'll admit I didn't read, but there were certain criticisms of the way Shine ran the case, and as you can see there, what she said is it was questionable in her view whether it was necessary for Shine to plead so many causes of action. The applicant's pleadings were convoluted and, owing to the cumbersome cross-referencing, often difficult to follow. Insufficient judgment was exercised about the number of experts that should be retained in each discipline. I think it was close to a dozen experts, the way in which the evidence should be elicited, and the documents that should be tendered. So obviously you've got a respondent who's running a very hard defence, but also the way the applicants ran the case was not efficient and led to additional cost. And as you can see, Justice Lee says there at in the paragraph 28, he doesn't want to be critical of the parties who've been running this litigation, but he wants to record his deep scepticism as to whether it was necessary to spend $82 million, and that's just for the applicants, in running this case. Like when you look at what Ethicon probably spent, you think they probably spent the same amount as well. So to run litigation of this nature and spend, well over $100 million is very questionable. And I must admit, I've run quite a bit of litigation at ACCC, and it's just mind-boggling that you could run litigation for that much money. I ran some big litigation, a number of week trials, and spent nowhere near that amount of money. Now, one thing that Justice Lee is very critical of is the evidence that Shine put on in support of its application to get this extra money. He described the evidence as far from pellucid, and there's quite a lot of focus on who was making decisions on how to fund this litigation. It was Mr. Raj, who was a financial officer, not a lawyer, working at Shine. And effectively there was evidence put on that various facilities which were already in place at Shine could not be used. So there was a BBL facility, said could not use that. It was a come and go facility, we couldn't really use it. The evidence put on only showed how much was available in these facilities at particular times, not over the whole period. Then the overdraft was considered unsuitable because the facility used to make capital investments, which seems a bit funny. I haven't heard of overdrafts being used for capital investments or meet existing liabilities. So there's really poor evidence put on by Shine to defend their position, and the judge came to the conclusion that all he could discern from the evidence was that Mr. Raj and Shine did not want to use the facilities for this particular purpose, this particular litigation funding, but he did not explain why they could not use it for this purpose. And again, he's commenting on the evidence. It's tellingly and worryingly absent as to the evidence of the involvement of individual solicitors in making decisions about how to fund this litigation. He didn't see any evidence of any input being put into the decision making by solicitor managers of the firm, which would have obviously involved some consideration of Shine's professional obligations as the lawyers to the group members. And he concluded that really it seemed that all the decisions about the funding was left to the money man, who had an understandable laser-like financial officer's focus on the financial interests of Shine Justice. So it's being somewhat critical here that the lawyers aren't involved in the decisions, and it doesn't seem to be enough focus on the ethical obligations that the lawyers had to the class. Furthermore, what is unexplained is why the decision to pursue external funding options was made notwithstanding that Shine paid dividends to its shareholders. And this is the fact that Shine Justice, which owns Shine Lawyers, is an ASX listed company. So here it's paying quite large dividends to its shareholders. As you can see there, that's a constant theme through Michael Lee's judgment. Why are they paying these dividends to their shareholders rather than maybe using some of these retained earnings to fund the litigation? Now, he concludes that the decision of Shine not to seek some sort of financial backing for the case early on appears to be decidedly odd, and I guess not having some contingency plan in place was puzzling to the judge. And he concludes that the view that the respondents would, potentially settle this case before going to trial was Panglossian, and I think for those, I had to look it up, but Dr. Pangloss was this eternally optimistic character from Voltaire's novel Candide. So saying there, to believe that it was going to be settled before a hard and fully contested case was Panglossian. And he concludes, Justice Lee, that they had a lot of time, more than ample time, to put in a different plan to fund the disbursements at a reasonable cost if they couldn't fund it out of their cash reserves. So what they actually did was got this arranged for this facility to be set up initially with AMG, and they subsequently went to another provider. But I think the essence of it is the same in both cases. Effectively, they set up this facility with a lender, and the key thing here is the interest rates were incredibly high. It was interest rates of between 22.4% and 31.8% per annum with AMG, and the subsequent company that they went with had similarly very high interest rates. So effectively what Shine are trying to do is to get the class, the group members, to pay these high interest rates, which they ended up paying on this particular facility. So the judge also notes that on implementing this particular disbursement funding facility, Shine received a reimbursement of the disbursements it had funded to that point. So effectively got $7.56 million out of this facility and paid it to itself. And see, here's the judge getting a little bit unhappy with Shine. He says, put bluntly, Shine used the funds borrowed at this incredibly high rate of over 20% interest to pay itself, with the hope that the interest cost of doing so would be paid by others. So here they're paying themselves $7.56 million from a facility that's charging over 20% interest per annum. And who's going to end up paying that? Ideally, you'd want the respondents to pay that, but if the respondents can't pay that, then it's going to be the actual class members. And then he notes again in the next paragraph that it was in the context of paying themselves a lot of money and incurring a high interest liability that they paid the shareholders of Shine Justice a final dividend of 2 cents per share. So he just interrupts his findings. This is in the context of case law that says that the interest on these particular types of funding arrangements aren't claimable against a respondent in litigation, and probably a number of reasons for that. I think the primary reason would be I thought they would be a tax deduction, so you probably shouldn't be able to get them out of a respondent. But what Justice Lee notes here is that even though some case law to say you can't get interest for a funding facility out of the respondents, he said that it's not necessarily a determined or finalised issue. He says that if it could be shown that the only practical way to fund particular proceedings was to incur a litigation expense such as a disbursement facility which had significant interest charges, there is no reason in either law or logic that the sum ought not to be recoverable from a respondent. So he's saying that really there's no binding precedent to say you can't get the money out of the respondent. However, the onus would be to show that there was no other option that you had that was less costly than this particular option. That might be quite a hard bar to get over. Then he was somewhat surprised that Shine didn't make a strong submission about trying to get the interest, saying that, well, this was the only option we really had, and so we are entitled to recover these amounts from the respondents. And here he's critical of them again, saying, well, why Shine did not have the bottle to try and recover in a determined way these amounts is puzzling to him. And I guess here he's saying, well, they could have put on a lot more evidence, a lot more compelling evidence, showing that the other options were not viable and making a very strong go to get these interest payments out of the respondent. And then he's speculating why they didn't do that. And he's saying here the registrar determined that the interest amounts weren't recoverable from the respondent. And he concludes that the only reason that Shine didn't have a red hot go to try and get these amounts back out of the respondents was because he believed that Shine may have been worried that a de novo review of all the costs and disbursements allowed would be a dangerous endeavour because the extent of recoverability could considerably come down. So there was a fear that they may not, if they pushed the issue and appealed it, that another decision maker may actually reduce the amount that they recovered. Now that's pretty negative conclusion to reach as to why they didn't go hard on trying to get this money out of the respondents. And I guess Justice Lee is speculating as to their motivations. He has to speculate because the evidence is so incomplete on these issues. And he says here as well, tellingly, the advice does not even attempt to explain why Shine thought the downside risk outweighed any upside. So why didn't they challenge the registrar's decision and try to get this money? Particularly when it must be recalled this was the only chance to recover the relevant sum against the unsuccessful respondents, rather than Shine banking upon getting the amount back upon any eventual settlement out of the pockets of group members. So here you've got a chance of getting the money out of the respondent. If you don't try to do that, the money's going to come out of the pockets of the women who've been injured by this product and who've got a very marginal settlement. So it's a very strange, and you can see Justice Lee somewhat confused as to the approach which Shine took to their application. Now, he notes there, having abandoned efforts to obtain recovery against the response, it meant the applicants would receive their ordered judgment sums unencumbered by any proportional payment for the relevant sum, but those they represented remained exposed. And again here, I think Justice Lee is showing his unhappiness with Shine. In blunt terms, the group members, rather than those who were acting as representatives, were now going to be left holding the bag. So the implication, probably more than implication, but the applicants have made poor commercial decisions, haven't appealed various issues that they could have appealed or challenged, and as a consequence, the applicants are trying to get out of the financial consequences of their poor decisions and poor actions, and shifting the liability back on the women that they're representing in the class action. There was also this interesting exchange between Justice Lee and Leopold, the barrister for Shine, and he's raising the question about the potential moral hazard that arises in this situation. So, and he says there in the first paragraph, so we're in a bit of a moral hazard here, which he's never come across before, and that's the fact that there's a positive financial incentive on Shine to settle rather than run the case to a conclusion, because you would not be able to recover these particular amounts from the respondent. So in order to make money, the company has to settle the case, which may not actually be in the best interests of the people they're representing. So he says there's a problem here where, I guess it says moral hazard, but there's a definite conflict of interest arising where the lawyers are potentially putting their own interests above the interests of the people they're representing. And then he says, furthermore, the fact that it's a publicly listed company, the only way it can make a profit and secure a return to its shareholders is by settling rather than running the litigation. So here, the conflict of interest between the people that are being represented in the class action and the shareholders of a publicly listed company or the partners of a partnership is being brought out quite starkly. And he doesn't explore these issues, but he clearly sees there's a problem here in the way things could work out. And then he says, at paragraph 143, Shine repeatedly stressed that it was placed with the choice of either entering into the disbursement funding facility on the term struck or ceasing to act. So this binary choice, he describes as a binary choice of just, we either enter this very unfavourable disbursement funding facility or we just pack our bags and cease acting. And he doesn't believe that this is established on the evidence. I don't think he put the evidence showing such a stark binary choice. But even putting that aside, he didn't believe that, Shine could just get up and walk away. Effectively, their retainer required it to act on the matter subject to termination for some just cause. Just cause isn't the fact that you're not going to make money on the case that you've picked up on a no-win, no-fee basis. Given the pendency of the initial trial at the time when Shine changed tack and ceased funding disbursements out of retained earnings, it is not evident to me that Shine did not have a duty to continue to act in the proceedings. Now, the thing is, if Shine had gone to the court and said, we're pulling out of this case, I don't think the judge would have let them pull out. I think fundamentally it's a submission they've made to the court which was unsupported by evidence, and I think was just fundamentally incorrect and probably unethical, in the sense that if they'd gone ahead with that, it would have been unethical. And then he notes at paragraph 143 as well, particularly given its protective and supervisory role in Part 4A proceedings, the federal court has a duty to ensure that that they would continue to act on behalf of the relevant group of people. They're hardly going to be allowed to pull out at a late stage in the litigation. And the implicit suggestion of Shine that the court would simply allow a firm operating a no-win, no-fee retainer to walk away for commercial reasons just before the trial is one I find difficult to accept. It would never have happened. They would never have allowed them to pull out. And he adds that he is far from convinced that if Shine said to group members in the court in a timely way that it would no longer act unless it exposed members to the terms of disbursement facility it negotiated, another proposal for conducting the litigation could not have been struck. So he's sceptical that had it got to that stage that they would have pulled out all stops to negotiate a more favourable funding arrangement. And then at 145, Justice Lee comments that Shine paid itself an amount representing past disbursements and exposed group members to usurious interest charges. So here it's paying itself money from the facility and the interest is racking up, and it was strongly the view that it couldn't get that interest out of the respondents, so the only person left to pay it would be the group members. And he's also critical of the amount of informational disclosure that Shine made to group members. So he effectively says that Shine told group members nothing about their potential liability for these very high interest rates, and didn't tell them that they potentially could have their settlement amount reduced by the interest payable on this disbursement facility. And so he concludes that the interest amount that Shine wishes to recover has two major problems in terms of undercompensating the class. The first is that the group members will bear this cost rather than Shine, and secondly, the total amount that will be recoverable by the group will no longer be in the range of what is fair and reasonable. So why should the applicants not bear the cost of their own poor decision making rather than the group? And if the amount is deducted from the total settlement amount, it goes from being borderline to below that. This goes to an unreasonable settlement amount. So as you can see there, consider a further deduction in excess of $32 million will make a marginal settlement less than reasonable. Borderline means borderline. The settlement got a grudging and hesitant pass, not a credit. So it's making it clear that it was really the minimum amount that was reasonable, and now they want to take an extra $32 million out of that amount. And then this is quite interesting comment. I think this is a bit that got quoted in the media when the judgment came out initially, but it's probably the second sentence there, which is somewhat strange. The settlement cannot be characterised as a good one from the perspective of good group members. Whatever belated attempts are made to put lipstick on a pig, or perhaps more fairly, a passably attractive sow. So it's a strange comment to make. Accordingly, I'm not satisfied that the net sum left for group members will be sufficient if the deduction sought is made. This is fatal to characterise the deduction now sought as just. So at that point, Shine's lost its application to try and get the $32 million from the settle amount. Now it's interesting here, Shine did not explain why group members should be burdened with this deduction. Why should they be left holding the can? It was open to Shine to seek to negotiate a different agreement, a different type of funding arrangement. It did not do so. No evidence was explained why it did not do that. And so that's a problem, and the failure to advise the applicants, the members of the class, as to exactly what was going on, puts them in an even weaker position. Now, they made this submission to the court that the opt-out notices gave the group members some notice of what was happening and that they may be liable for this amount. And he said that the submission was put hesitantly, and it was right to be hesitant to put the submission because it's obviously very weak and maybe sort of on the spot. And Justice Lee had a contradictor in the case to present the arguments as to why this wasn't an appropriate settlement. And as the contradictor submitted, the interest was paid at an eye-wateringly high rate on Shine's disbursement for funding facilities, and it was not within any ordinary group member's expectation of what the costs would be. So they wouldn't be expecting that the law firm would have entered into a disbursement funding facility where they're paying over 20% interest. And the failure to give any notice of how large this amount would be to the group members, again, he says, was fatal to characterising the order now sought as just. So the conclusion is that they can't get the money back from the settlement amount, but there's also other strange things that occurred in the case. And so Shine received a large payment of funds and received these funds and then put it into a trust account bearing absolutely no interest, and they left it there for almost 1 year. So again, the judge is just curious why large amounts of money are being received by Shine and left in an account that doesn't bear any interest. And now they're trying to, so I guess effectively there was no effort to mitigate the effects of the disbursement facility by investing funds in interest-bearing accounts. So that was a very strange, in Justice Lee's view, a very strange decision made by Shine. Again, when they received some payments from the other side, from the respondents, they didn't seek to pay down the facility that was subject to a 20% interest rate. So they basically kept the money. They chose not to repay the money in the facility, and as a consequence, the facility remained, I guess, overdrawn in a sense, or drawn from, and interest rates accrued, or interest accrued. So as you can see there, that rather than pay the money into the facility to pay it down and thus reduce the very high interest that was being charged, they didn't do that, and in a very short period of time, $8.6 million of additional interest accrued in a relatively short period of time due to the fact that they were subject to a 20% interest rate. So these are the kinds of issues that the judge doesn't quite understand why Shine made these decisions, like not paying down the facility, not putting large amounts of funds in interest-bearing accounts, making a lot of very poor commercial decisions that all impact the group, and then expect the group to effectively compensate Shine for its poor decisions. So as you can see, there were a lot of different options available to Shine which they did not explore, and that needed to be explained by evidence. They need to say why they couldn't have chosen any of these other options. And I think he summarises it well there. The choices that Shine made reflected commercial decisions made by a public company. If those commercial decisions have turned out, with the benefit of hindsight, to be suboptimal, that does not mean it is just that women, including a number who have suffered profound personal loss, should ameliorate the consequence of these commercial decisions. So I think, even the statement with the benefit of hindsight is somewhat charitable to Shine, because it's not a question of with the benefit of hindsight they realise there were poor decisions. Putting a large amount of money in an account that doesn't bear any interest is a bad decision at the time you make it, and not paying down a facility that you're paying 20% interest on when you can is also a bad decision at the time you make it. So I think the decisions were bad decisions at the time they were made. So the next steps. So Justice Lee decided to dismiss this application, but he said that it does not operate as an insuperable fetter on bringing a further application. So Shine can bring a further application to try and get this money, or obviously a lesser amount. So if they want to come back and try to get a lesser amount than $32 million. But then he says, if you're going to come back and try again, you have to make sure you have some proper evidence on. And you've got to really explain the decisions you made. You've got to explain why you did not act imprudently or unreasonably in entering this particular facility. And you've got to explain to me how is it possibly just to allow any deduction from this very marginal settlement. And then he says, it's unfortunate the legislative scheme in Australia for personal injury damages is problematic. So he's commenting on the legislation there that women aren't able to obtain sufficient compensation to help them get on with their lives. But then he makes this very interesting observation that he has not found it necessary to reach any conclusion as to whether Shine acted contrary to any legal duty, and that's effectively any ethical duty, in going down the path it chose. But an alternative application may require consideration of that issue. So I think he's firing a bit of a warning shot over Shine, the bowels of Shine, to sort of say, well, you can try and make another application. Firstly, you've got to put on significant evidence, explain why it is just for these women to pay for your mistakes, effectively. But you've also got to explain to me how your ethical duties weren't contravened by some of the decisions you make. And if you do come back and you do try again, Justice Lee saying, I'm going to look at that issue very carefully. So I think if I'm Shine, I'm thinking I'm not going to risk it. He also makes this comment in the towards the end of this judgment that if they do come back again, he would have to understand better than he does currently why Shine changed tack and decided to expose members to the extraordinary interest charges. They need to provide a clear explanation based on evidence as to why they did this. And I think some of the other decisions they made, they're going to have to explain them. The decisions I referred to before about putting amounts in accounts that didn't produce any interest and not paying down the amount of the facility that was charging 20% interest. So they're going to explain all that. So his final comment is, I'm not encouraging a further application, but if you do come along, if you do want to make a further application, it's going to be pretty intense forensic exercise. You'll be assisted by the presence of a contradictor. There'll be discovery, there'll be cross-examination, and you're going to have to explain to me very firmly as to why any lesser sum than 32 million should be deducted from the settlement amount and why that would be just. So I think there's a very strong suggestion to Shine that they should just leave this particular matter at this stage. So it's an interesting judgment. I think it shows some very poor commercial decisions made by a very experienced class action firm and really inexplicable. A lot of those decisions are very strange. The judge can't understand them. The parties, as you can see there, Shine did not present compelling evidence. It really didn't provide evidence to explain the decisions it made. it made pretty bald assertions that it couldn't do certain things, but didn't explain them. Why it couldn't use its existing facilities to fund things. It it seemed to leave a lot of the decisions up to financial individuals with no input from legal managers of the firm. So that's a concern. There's clearly a need to ensure that your ethical duties are being met. Also, the door is open to Shine to try again, but there's a strong suggestion by Justice Lee that it might be very risky to go down that path. A, you're probably not going to change his mind, and B, he might start looking at some of the other issues about ethical issues and legal obligations, and that could be problematic for Shine if he starts looking at those issues. So I think there's a very strong warning there not to try again. It's very important for class action firms to just avoid these types of situations because, there's a strong view in some parts of government and some parts of politics that the class action regime needs to be reined back, and it's very important that class action firms don't make decisions which negatively impact on the whole industry. And I think here a lot of these decisions were very poor, and it really needs to have a good look as to why its decision making in relation to this particular litigation was so poor. And people will point to this. They point to the few bad examples of the management of class litigation to really tar the whole industry. So it's important that class action firms avoid these types of situations in futures. The question that hit me a bit is if they're paying massive interest on this facility, would that be tax deduction? I don't know. I'm no tax lawyer, but it seems to me that it'd be a deduction. Like I guess even if you pay usurious levels of interest, you still can claim as tax deduction. I don't know. That wasn't mentioned by the judge at all, but it seemed to me that it'd ordinarily be a tax deduction. And as I said earlier, Shine would be best to walk away from this case. I think trying to go again in front of Justice Lee isn't going to be successful. It potentially could damage the brand, the Shine brand, even more. And I think this is just a learning experience to walk away. So that's all I had. Hopefully that's been helpful. And if you have any questions, feel free to give me a call or send me an email. Bye bye.